Be ready. Start. The Central Council of Indian Medicine, for short the Central Council, is a statutory body constituted in terms of Section 3 of the Indian Medicine Central Council Act 1970, for short the Act. Section 4 of the Act mandates that election under Clause A or Clause B of subsection 1 of Section 3 of the Act shall be conducted by the central government in accordance with the rules as may be made in this behalf. Where any disputes arise regarding any election to the Central Council, it shall be referred to the central government, whose decision shall be final. Subsection 1a of Section 3 provides that the Central Council shall consist of such number of members not exceeding 5 as may be determined by the central government in accordance with the provisions of the first schedule of the Act for each of the Ayurveda, Siddha, and Unani systems of medicine from each state in which a state register of the Indian medicine is maintained, to be elected from amongst themselves by the persons enrolled on that register as registered practitioners of the respective systems. Section 3 1b of the Act states that one member each of the Ayurveda, Siddha, and Unani systems of medicine from each university were to be elected from amongst themselves by the members of the faculty or department of the respective system of medicine of that university. The central government could also nominate such number of members not exceeding 30% of the total members elected under the above mentioned clauses A and B to the Central Council from amongst persons having special knowledge or practical experience in respect of Indian medicine in accordance with Section 3(1)(c) of the Act. These elected members are to elect their president, to be known as President of the Central Council, and a Vice President for each of the systems of medicine. This elected Central Council, so constituted, is to discharge various functions and duties as contemplated under the provisions of the Act, which include the grant of recognition to medical colleges, stroke courses, maintenance of education standards, appointment of inspectors, conduct and supervision of examinations, and even the withdrawal of recognition if necessary. A register is to be maintained of the persons possessing requisite qualification in the type of medicine which the member is eligible to practice and who have been registered by the state board, and which register has to be updated with regard to the qualification attained by members of the respective professions subsequently. As is evident from the above narrated provisions, the Central Council discharges very significant and important functions which would affect not only education in these three systems but even their practice and treatment of thousands of patients under these systems. The statute places an obligation upon the central government to hold the selections and ensure that the Central Council works smoothly and in accordance with the provisions of the Act. Section 7 of the Act refers to the tenure that an elected member is entitled to enjoy upon his election to the Central Council. This section deals with the term of the office of the President, Vice President, and the members of the Central Council. The term of office for all these persons is 5 years from the date of election or nomination, as the case may be, or until a successor has been duly elected or nominated, whichever is longer. The latter part of this section caused serious impediment in the proper functioning of the Central Council, primarily for two reasons. A. The central government did not take appropriate steps to hold fresh elections, and B. The persons who were elected and were interested in continuing as such took advantage of this provision and continued in office far beyond 5 years, as nobody was duly elected to replace them. Obvious from the prayers is that the petitioner firstly wants a direction to the Union of India to discharge its statutory duty in terms of Section 3 of the Act to fill up the membership of the governing body of the Central Council with regard to the members who have completed the term of 5 years within the stipulated period, and secondly, the striking down of provisions of Section 7 of the Act as unconstitutional, undemocratic, and violative of Articles 14 and 16 of the Constitution. It is the contention of the petitioner that the elected members of the Central Council are adopting delaying tactics and even invoking the jurisdiction of the High Courts to stop the holding of elections or the declaration of result of the elections wherever held, notwithstanding the fact that there is an alternative remedy available to them of filing an election petition. The inaction on the part of the government borders on complicity, and with the passage of time, vested interests have developed. There is a specific averment in the petition that the Union of India and even the members of the Central Council are not evincing any interest in the functioning of the Central Council, and a few unelected members whose term expired long back are squatting for an inordinately long period as being erstwhile elected members of the Central Council with the aid of language of Section 7 of the Act. Thank you.